Hello, my name is Kristen Wolgamuth. I'm president and CEO here at Mountain States Legal Foundation, and I am joined today by our senior leadership in our legal team to talk about the great work that we had the opportunity to do this year on behalf of our Constitution and on behalf of you here from our home base in Lakewood, Colorado. Tonight is our Christmas party, and never is there a better time to sit still and think about the things that we're thankful for this year than in this wonderful holiday season that we find ourselves in. With that, let me start with just introductions all around. Jim, would you start us off and tell us who you are and where you're from?
Thank you, Kristen. Happy holidays, everybody. My name is Jim Kerwin. I'm in charge of the free speech practice here at Mountain States Legal Foundation.
Perfect.
And I'm Will Tackman. I'm the general counsel here. I practice primarily equal protection and civil rights law.
I'm Mike McCoy. I'm the director of the Center to Keep and Bear Arms.
Ivan Lind, I'm the head of our natural resource and litigation, energy litigation area.
Fantastic. And with that, we're just going to jump right into things. Again, this is just a broad overlook of everything that we had the opportunity to work on this year. And it is a bit lighthearted because we get to share, again, the great work that we get to do and the precedents that we are striving for, but also just what it's like to be here around the foundation working on things that only lawyers get super geeked out and excited about. So with that, I'm going to start, Ivan, if you don't mind, start us off. This is the question of that we're going to start with. Tell me what your favorite case was to work on this year.
Well, it was nice to start off with a win.
Yes.
So on January 9th, we received a great win in a case we have for our client Rayco out in federal court in California, a long-standing mining case where we argued that the Department of the Interior had unreasonably denied and frankly delayed for decades ruling on patent applications for a family mom and pop mining company out there. So we started the year off with a win in that case. So that's been really rewarding, and we've been continuing to work with the Ray family and Rayco and been vindicating their rights before the Department of the Interior. So that was a good start at least. We followed it up pretty quickly with another win actually in a long-standing case, our bighorn sheep case here in Colorado, where we supported actually the federal agencies and who decided that it'd be okay for our clients, ranchers, to raise sheep out in southern Colorado. Much to the anti-ranching group's dismay, federal court upheld a ruling that our clients could graze sheep out there. So we got off to a pretty good start. Now that was, favorites are tough to pick all the time. I don't want to hear it, but I really enjoyed. So I got the pleasure early in the year to argue summary judgment in our Idaho stockwater case, where we also, working on behalf of ranchers up in Idaho on a question about whether the United States can decide it doesn't have to follow the law anymore in regard to water rights in the West. That's been a fun one ongoing. We got a great result there in late August where the court agreed with us that, in fact, the U.S. can't opt out of its obligations under federal and state law.
All right. So, Ivan.
Oh, my gosh. I got one more. That's a lot. Even more fun coming. Because in the meantime, okay, I'll save it.
So of those three, those are, in fact, fantastic wins on behalf of a number of mining and ranching interests. Mm-hmm. Which one was your favorite?
Favorite's the fourth one, actually.
Of course it is.
Our client, Ace Black Ranch, is up in Idaho. This is a family ranch up in Idaho. The federal government has decided that the ranch should have to spend millions and millions of dollars to turn ranch land into natural wetlands. And we have stepped in to argue that no, in fact, the federal government has no authority to tell them what to do on their property because these aren't federal wetlands. And in that case, it was filed by the federal government back in February, and we got a motion to dismiss granted at the end of August, forcing the government to start from scratch and standing for a proposition that you can't just bully landowners around.
I think that all four of your favorite cases somehow they actually do all tie together pretty nicely because one of the things that we work desperately hard on in our natural resources practice is to ensure that people have the opportunity to use their land, their property the way that they see fit. And in each of those, I think there were four of them. So you'll have to correct me if I'm forgetting one.
Don't worry,
But I think that each one of those is tied very nicely together with that concept.
I think that's right. And they also ties really closely to all the energy and natural resources work we do more generally, right? Whether it's oil and gas, mining, forestry and active forest management. All these cases have some common themes about whether it's unlawful regulatory action or just unreasonable action. What does the Constitution, what the laws require?
Right. Okay, Will, let's see if you can follow instructions because I can't. Can you give me a favorite case that you got to work on?
Well, I think Mike just said it's like choosing between your children, but imagine if you had 50 children that you had worked on throughout the course of the year. So I'll pick one involving the Title IX regulations because for me this was personal. When I was in the Trump administration, I worked on Title IX as part of the Civil Rights Project, trying to put due process into campus controversies. And the Biden administration had targeted Title IX from the get-go. President Biden, in the first few days of his administration, said, "We're going to try to undo all of the good reforms that President Trump did in his first term." And so it took them quite a while to actually get anything over the finish line. They started announcing these plans in January of 2021. Finally, by April of 2024, they promulgated their Title IX rules, which, among other things, reversed all the due process protections that had been in the old rule, and then imposed sexual orientation and gender identity restrictions on schools throughout the country. So even in the most rural school in Mississippi, you would now have to respect someone's preferred pronouns, no matter whether they were he, she, they, or them. And this was not just an equal protection issue, but also a speech issue for Gemini. And so within weeks, we were in court. We brought a case in the District of Kansas with the state of Kansas, some other states, some other organizations, and we got a preliminary injunction on behalf of our clients, Moms for Liberty and YAF, the Young Americans Foundation. And the greatest thing about the injunction is that it continues to expand. The judge said every new member that joins one of those organizations now has my order protecting them. So we've had Moms for Liberty and YAF run recruitment drives based on this order because that protection from the Biden-Harris administration continues to expand. And so thankfully, those preferred pronoun policies have hit a brick wall. And of course, with the change in administration, we may yet see even more changes to Title IX.
And if I understand correctly, we have an order from the judge to periodically supplement the list of schools that are covered by this order because of the recruitment drives that are continuing to expand the implications of this preliminary injunction.
That's absolutely right. So we are limited almost by only our own amount of time because schools keep joining this list, and we have to continue to update the court and say, aha, now there's a YAF member at Carnegie Mellon, for instance. And so Carnegie Mellon can't have a preferred pronoun policy based on the Biden-Harris regulations, or they can't undercut due process measures. So every few weeks, we're updating the court saying, here's another tranche of schools that are subject to your order, and it's going to keep coming. And so the Biden-Harris administration has really objected to that, saying you shouldn't let the injunction continue to expand. And the judge said, no, that's my order, and I'm standing by it. So we're very pleased.
So this is going to be a case that extends into 2025, right? Right now, all we are working off of, as delighted as we are with this preliminary injunction, this is the first step in that case, right?
Yeah, like many things with the federal government, things move slowly. So as I said, it took the Biden administration over 3 years to actually issue the rules. And now the Trump administration, as they come into office in January, is going to have some decisions to make about whether to stay the rule, that is, postpone the application of it. We, just to be clear, are not going to stay our case. We're going to try to get a definitive ruling that these regulations are invalid, that they're unconstitutional. And so whether or not the Trump administration spends the time that they want to spend prioritizing them, we want to get a clear rule that at least the Biden regulations are invalid. So yeah, 2025 for sure. We'll have to see again what happens. The Department of Education, we've heard a lot about recently, maybe going away. So we don't know necessarily how many people are going to be in the department trying to roll back what happened just this year.
Very good. Thank you. All right, Mike.
So I do have a favorite child and a favorite case. Well, my favorite case for sure. And that's the Vanderstock case. And it's easy to explain why this case went to the Supreme Court, as hopefully most of you are aware of, just last month, or actually October now, it's a month and a half ago. For an attorney to go to the Supreme Court, it's like going to the Super Bowl. It's a rare event, and it was really quite monumental for us. for our client, Jennifer Vanderstock, and hopefully for the precedent that will be set through that case by the Supreme Court. And just by way of background, that case involves the ATF doing what it has done a lot during the Biden administration, which is engaging in executive branch overreach, deciding that Congress has not done something they want Congress to do. And rather than going to Congress and doing it the constitutional way, which is to get Congress to pass legislation, they decided to do an end run around that entire process, ignoring the separation of powers that our founders so carefully put into our Constitution. And they decided that they wanted to start regulating materials that were being used predominantly by people who like to manufacture their own firearms or privately made firearms at their homes, and basically put the same regulatory requirements on them as you would on a commercial firearms dealer or seller of some sort. And so we're pushing back on that. We have pushed back on that. We had arguments again in October, and we're hoping for a good decision from the court here in the next few months.
Very exciting. It was actually an incredible experience to get to go to the Supreme Court. It's the first time the foundation has been one of our cases, our direct representation cases, has been in front of the Supreme Court in about a decade. And so it's an exciting day to get the court to sit up and take notice about something that you're working on.
Because to be part of it.
That's
a huge team effort to get that there. So
absolutely.
I remember we were waiting out in the cold in order to get into the court. And just in the last few days, the court announced we're doing a reservation system. So, when we're there next year, we'll be able to take advantage of that.
All right, Jim, wrap this question up for us. Favorite case of the year?
Sure thing. So I think mine is a little bit of a sleeper. You know, we had some very big news-making cases, including the Title IX case that's partially in the free speech area. But there's one case that we just got a victory on this Monday that maybe in the long run will have more of an impact for Americans because it could potentially affect workplaces across the whole country. And that's the case of Danielle Johnson versus Oregon Department of Environmental Quality. This is a case that we launched earlier this year on behalf of a public employee whose employer runs very aggressive DEI programming that includes many very hostile opinions about race, in particular white people's races, and their purported inability to understand others or to be empathetic and things like that. This is a common thing in many workplaces, and ours is among very few cases around the country that has now, based as of Monday, survived the first round of motion practice, and it's going to be allowed to go forward. We just got a decision from a federal court allowing this case to go forward. It also has an important free speech aspect in that our client was brave enough to speak up and question whether her employer was violating the law by running race-based preferences in employment and these other things. And she really had, they brought the hammer down on her, they demoted her and they cut her pay, and they really tried to silence her. And it's very, very important that she wins this kind of case because other people see what happened to our client, they see what's happened elsewhere in the culture, and they are quiet. And when people self-censor that way, that's how these abuses really just, take deeper root in society, keep perpetuating themselves.
I think that's one of the most interesting pieces about your work, Jim, is how diligently you are working to ensure that people can have the confidence to not self-censor, but to speak their mind as we always have. That's one of the things that makes America such a vibrant society is our ability to speak and agree and disagree with each other and form our opinions in an intentional, intelligent way rather than simply accepting what somebody has told us because that's the marching orders for the day. So
Yeah, I think that's right. I do think, there have been some dark times for free speech lately, but we've had some very significant victories at Mountain States Legal recently, and so have others. And it really does feel like there's starting to be a tide turning in this area, which feels really good.
That's fantastic. All right, let me shift the question a little bit. What case did you work on, or what can we say will forever be preserved or will never happen again in our society because of the work that we did here at the foundation this year? And who,
I'll go first. I have
go for
18.
it. Hey,
No,
excellent.
no, I'll go back to the Ace Black Ranches case I mentioned. That case is ongoing, but we made a really strong point and got a great victory early on in the case to say that when the federal government wants to come onto your property and tell you what to do, they have to have a really firm basis for thinking they can do that. And they can't just bully you. They can't just push you around and say, it's so because we say it's so. And we have a federal court agreeing with us and tossing an entire complaint. Now they've refiled it and they want to say more things. And that's okay. That's part of the process.
Right.
But having that be the precedent that there are real rules about the federal government coming onto your property
Mhm.
and the federal government has to follow them. And even before proving its case, has to at least explain to you, the landowner, why they think they have the right to do that in the first place. That's a really great win that I think will have ripple effects throughout the country.
I think that that's one of the more interesting parts of that case, although that part I think has mostly been laid to bed. The government began by simply asserting this is a wetland without any evidence
That's right.
and expected the court to say, oh, well, of course, it's
That's
a
right.
wetland because you said so, right?
That's right. And we have standards that are higher than that for getting to federal court, but those standards should also apply to the first thought of, hey, should we go on these private person's land and tell them what to do? And I think that the order we got from the court dismissing the complaint speaks for that very clearly.
Very good. I had the opportunity to visit the Black family and walk around the ranch, which is beautiful. But my boots weren't particularly sticky with
We,
mud as I was walking around the ranch.
Our briefing does comment on that. This case involved investigations on the property twice over the last few years for 7 days total. There were marshals with guns involved, and we did ask the question in our briefing. Hey, the government has said that they can bring these claims because they have this investigation. These are all wetlands. They were out there. Were their boots wet? Do they have any pictures? They don't even say, right? They just let the court draw the conclusion that they're right just because they say so. And we pushed back on that approach to regulating and to litigation. And it's great to get a win there.
All right. I can call on you guys, but do you all want to just raise your hand now that I've given you a chance to think about it?
So I have two, and one of them is Ivan's. So technically, you should put it on Ivan that he's doing more.
Told you I have 18, right?
So just over the summer, a landmark case called Loper Bright came down, and this is a case that reversed what was called Chevron deference. And that's the doctrine that if a court is reviewing whether or not an agency is doing something that's consistent with its power. So Congress gives an agency power, the agency then acts, and then the agency says, okay, here's our action, it gets challenged in court. The agency was allowed to have deference that they did something that was within their power. And that doctrine had just taken on a life of its own. It had made Congress basically put its hands down and say, we don't have to figure out difficult problems. We can just delegate all these issues to the agency, then the courts will uphold them. And that got reversed in this summer's term, thanks to Ivan filing a terrific amicus brief in our brief talking about the need for change and not being bound, even though this doctrine has been around for 40 years, not being bound by a false and unconstitutional interpretation of agency power. Okay. That's Ivan's. Mine. Mine's called Searle, and it involves a very sweet 70-year-old woman named Christine Searle, who owns a house in Arizona, and she got behind on her taxes and ended up owing about $1,600 in delinquent taxes. And part of Arizona law said that when that happens, we can take your house, auction off the deed to your house, and give it to a private entity, and then they own your house free and clear with no need to give you the difference between what you owed and the value of your house. We brought a lawsuit in January of this year, and within a few months, the Arizona Attorney General confessed, not essentially, they did, that this law was unconstitutional, and the state legislature changed the law at the behest of the Attorney General after we brought suit. So it's actually never happened to me in my career that the Attorney General that I'm suing says, you know what, you're right. We have been acting unconstitutionally. Now the case continues for other reasons, but when you ask what's never going to happen again, I mean, never again in Arizona is someone like Miss Searle going to be hurt by Arizona law that says we're going to take your whole house away for a minuscule tax debt.
Which is brilliant.
Yeah.
It is a follow-on case to a Supreme Court decision that happened, was it last term?
That's right. So in 2023,
Mhm.
a case called Tyler v. Hennepin got litigated. And in that case, it was the county that took the house. In Ms. Searle's case, it was this private real estate company. And so they claim that there's a difference between Tyler and this case. Obviously, we don't agree, but that's why the case is ongoing still.
Which is a testament to the diligence of government to find an end around, to do what they want to do, no matter what the Supreme Court or Congress has given it the authority to do or not do. All right, Mike, I think that we've fallen into a pattern here, so I think you're up next.
So I think I feel a little bit of a disadvantage because I've only been here for 7 months. So as far as something not happening again, they're all in the works.
Yes, sir.
There's a lot of new cases that we filed that are Second Amendment related. 2 cases related to waiting periods in Colorado and New Mexico, as well as another ATF rule, another end run by the ATF around the legislature, dealing with firearms dealers and who qualifies as being engaged in the business. Those are all things that we are hoping, and I believe that over the course of this year, we're going to see some good results coming out of. And I hope to be back here next year and saying that those are things that are not going to happen again. Hopefully.
Brilliant.
Yeah.
Brilliant. All right, Jim.
I'm ready. So I would say that there's a case out of the Supreme Court that we weighed in as amicus curiae for, called Vulo, which involved an effort by the New York State Commissioner of Insurance to basically run the National Rifle Association, out of business in New York by persuading other companies not to do business with them, not to write insurance policies. And that was found to be a violation of the First Amendment by the Supreme Court. They weighed in on the side of that. The state had argued that, there's this doctrine called government speech, where in certain circumstances, if people bring a challenge to say that the government has to carry a message that I agree with if they're saying something else, the state had really twisted that doctrine to say, well, that means we're immune from things like bullying third parties into silencing the National Rifle Association. And the Supreme Court had none of it, thanks in part to our briefing. We'd like to thank. And I think so that will never happen again.
It's a unanimous decision.
There you go.
And the government speech doctrine is pernicious. We have another case called Advanced Colorado where the government is claiming that they can misframe our client's speech because technically it's their speech when you put it on a ballot. So that doctrine is just popping up in so many places, and I'm very happy that Jim pointed out the idea that we got to attack that doctrine on all fronts, and Vulo is a great example of where you can get 9 Supreme Court justices to agree that it doesn't apply there.
All right, I have saved the geeky lawyer question for the last one, which is, what case gave you an opportunity to work on a deeper issue or a deeper matter that you don't typically get to work on in a for-profit in a for-profit law firm?
Certainly, I'll go first.
Of
That's
course.
the pattern in practice.
Of course.
Well, Ace by Great is a good example, but I don't want to harp on that one. I've brought that one a few times now.
Yes, sir.
We have some real good deep thinkers in our Supreme Court work right now. One being the case Utah versus United States, where the state of Utah is challenging the premise that there should be a federal regulatory state over the West, basically at all. The federal government can own and control, millions upon millions of acres in the West. We represent several Wyoming legislators in that case. The question, yeah, exactly. What does it mean to be a sovereign state if the federal government actually says it can own and control more than half the land or half the minerals in your state?
And just for clarification, in that case, what Utah is arguing is that because the federal government owns, it's over 50, but I think it's up to 80% of the state.
Depending on where you are, and which state you're in. I don't know if Utah's quite that high, but Nevada, for example, is.
Okay.
We represent, like I said, several legislators in Wyoming, and even the mineral state there in the United States, the federal government claims to own greater than 65-70% of the minerals in Wyoming.
Right.
And so the premise is, we are Utah, and we are joining Utah and asking the Supreme Court to take on this case and address this question. Is it fair under the Constitution for Congress to hold on to this land for the federal government as opposed to just giving it to the states to run.
Mhm.
There's that. The other issue is a deep thinker issue that's a lot of fun. These questions that have been coming up, certainly even in the recent arguments in the Seven County case and in the case separately that Will and I have worked on at the DC Circuit. But what is the role of Congress in setting and establishing the public interest? And when can regulators or Article 3 federal judges decide that their interests weigh more than the public interest as set out by Congress? So we've had several cases in that area, and these apply across energy, mining, forestry, oil and gas, all the above. So they require a lot of deep academic thought, but they apply everywhere.
All right, Ivan has already given 2, so you are stuck
Right.
with 1.
All right.
So I was going to say Searle and Advanced Colorado, but I've burned both of those by mentioning them. So there's so many deep cuts in our business where you're all of a sudden thrown into a new area of law and have to figure out for the first time, oh, this is something I hadn't even thought about. And I'm going to actually steal Mike's case on this one.
Oh,
So Mike is representing these very sympathetic gun owners in New Mexico in the Ortega matter, where there's a 7-day waiting period. And as most of our viewers probably know, in 2022, the Supreme Court announced that there's a very simple test for Second Amendment cases. 1, does a Second Amendment apply? And 2, can you find a historical analog sufficient for the government to match the new regulation? And I always thought that first part was going to be pretty easy, right? Does a Second Amendment apply? And here we've got a waiting period on a purchase of firearms, and yet the government is saying the Second Amendment applies to keeping arms, it applies to bearing arms, but it doesn't apply to buying and obtaining an arm of all things. And what's amazing is that some of the courts, like the one in New Mexico, have bought this argument. But in the meantime, we've had to marshal all these other cases, including in the First Amendment context, where some people have said, a prohibition on ink or paper doesn't actually impact the First Amendment. But of course, the Supreme Court has said it does do those things. So we've had to navigate all these other cases in other contexts where we've said, of course, obtaining the necessary underpinning of the right counts. And so I am hopeful that the appellate courts will side with us in that case, because it seems absurd to me that anyone could say obtaining an arm, buying an arm is not part of keeping and bearing. But in terms of the deep cut, having to look through all these old cases about what the First Amendment covers, what other amendments cover within their ambit has been really enlightening for me.
Very interesting.
yeah, and I will say that on those cases, we've been consistently running into headwinds, to say the least. But I almost think it's winning through losing, because ultimately, I think the Supreme Court's going to have to weigh in on this waiting period. And just so it's clear, we're not talking about a delay in acquiring a firearm that's based on a background check. That's a separate issue. In both of these cases, both in Colorado and New Mexico, these are arbitrary waiting periods that are levied against law-abiding people who have passed their background checks, have no reason why they cannot possess a firearm, and they're just told that because we don't want you to have it, because we think you might be impulsive with it, you can't have it for 7 days. As someone who's been a prosecutor for 25 years and spent a good portion of that time working domestic violence cases, I say that is the most reckless thing you can do, is when someone, particularly a victim of domestic violence, is looking to purchase a firearm, tell her to go home to her house, and just hold tight for 7 days before she has the ability to defend herself. So they are deep cuts. That's been frustrating. Some of the rulings coming out of the district courts for sure, but I'm hopeful one of these cases will actually maybe take us back to the Super Bowl for attorneys. The Supreme Court will finally weigh in on these arbitrary waiting periods.
Absolutely.
So I will say, I think I might have said this last year too. We have a big picture project to address the issue of qualified immunity in First Amendment cases, and just very brief overview of what that is. There's a doctrine that was developed by the Supreme Court maybe 40 years ago that says when the government has violated your rights, but it wasn't clear that they were violating your rights, they kind of get a second bite of the apple, right? They are not liable for damages unless it was pretty clear that they shouldn't have done what they did. While that doctrine was originally created in the context of law enforcement, where people's lives and property might be at stake, but it's sort of unthinkingly been ported into the context of the First Amendment as well, where there's no, generally speaking, there's people's lives and property are not at stake. And it encourages government actors to kind of play close to the line. They know they're going to get a second bite at the apple if they violate your rights. So they are incentivized to try to, get as close to what's unconstitutional as possible. The incentive should be the other way around. They should be staying far away from the line. And it's a big project that we're working on that will take many cases. We raised this in essentially all of our First Amendment cases. As of yet, we haven't gotten it up to a court of appeals, but this will ultimately probably require going to the Supreme Court over the course of years.
So just to further discuss that particular point, I believe that qualified immunity was actually originally created specifically for law enforcement. In the heat of the moment, they are trying to decide whether to shoot or not shoot or things of that nature when there is true life and limb on the line. And sometimes those split-second decisions must be split-second decisions, but you're operating on the information that you have available, right? Rather than having the opportunity to say, hold on just 1 minute, and let me go do a background check on you and see if you're likely to do whatever heinous thing is about to happen. How did it find its way into the First Amendment? Because the situations, it does not seem to be applicable in any way, shape, form, or fashion.
So unfortunately, in the law, it's very common for courts to seize on verbal formulations. You're absolutely correct. The original impetus for this doctrine, excuse me, and the context in which it makes the most sense is that split-second law enforcement decision. You don't want police officers, so the argument goes, which is somewhat persuasive, to second guess themselves, to not be bold enough to take an action in the moment that might save somebody's life. But the court, when those decisions were made, they put the doctrine in a somewhat succinct manner and say, when the government makes a decision, and it's not clear, based on the laws that exist at that time, that it's unconstitutional, they essentially, they have qualified immunity. All that happens then in the cases that move forward, courts just take that language and they don't look at the specific facts of the original cases that involve law enforcement, and they take the language and they use it unthinkingly, is what I would say. And sometimes it may be ideologically driven. It's hard to say, this is doctrine that's developed over the course of 40 or 50 years. And so it's going to take some time to push back on it. In many different contexts, the one that I care the most about is the First Amendment, though there are others. It's unclear to me why a government official who may violate your equal protection rights should also feel, be incentivized to kind of get close to the line there. That doesn't make sense to me either.
Absolutely. Well, speaking of big projects, we have one that we are pushing for in the next year, which is going to be another one of those long-lasting projects in an effort to slay a similarly Goliath issue, which is our Center for American Prosperity and Energy. Do you want to talk just a moment about what we are hoping for in 2025?
Absolutely. And just briefly.
Yes.
A number of our cases historically have been rooted in energy production, use of resources, especially in the West. Talk about oil and gas, mining, forestry, and forest management. And we are concentrating even more fully on bringing the best cases in those areas to light to kind of push back against maybe a nationwide, at least federal regulatory attack on those industries and those great uses of our resources in the West and the nation.
Very good. As you've had the opportunity to hear our attorneys talk about the great work that they have done all year, I hope that you join me in being incredibly proud of the work and the vision that these gentlemen lend to each of the issue areas that Mountain States fights for. I think that is going to be increasingly important. As excited as we are to have a liberty-minded president, a liberty-minded administration, a liberty-minded Congress coming into office in the next month. One of the things that that I am very concerned about is that those who we typically fight against have lost every forum excepting the one we happen to fight in. And so one of the things that we are expecting in 2025 is to see a landslide of cases filed in the courts, because the people that we fight against are not going to have a friendly forum in our Congress for the next 2 years and in our White House for the next 4 years, which makes the courts really the only forum available to them. And so we appreciate your support, and we are grateful for every single one of you who stands beside us as we fight these incredible battles. And we continue to look forward to working alongside you, and are grateful for your continued support in 2025, because these guys are going to need it. So with that, thank you so much for all you do to support the foundation. Thank you so much for listening in to our joyful review of 2024, and we look forward to visiting with you again in 2025. Merry Christmas, Happy Hanukkah, Happy New Year.